Almost ready to get started. I see you, Jenny. I'm so glad to see you and everybody. Um, we have 111 people uh, in the room so far, and no doubt we will be uh, joined by many more. But I think we have a lot to talk about today, and it's probably time to get started. Can everybody hear me okay? That's an important question. Well, welcome everybody to the what we call, for a lack of better name, a Black Lives Matter virtual teach-in. I am so grateful to everyone who has made this day happen, including all the faculty we reached out to, every one of whom immediately embraced the opportunity to engage here, to the staff who supported this, to the wonderful students, including an incredible group of student leaders who really came together in the last 48 hours. The amazing slides you saw happened in the last 24 hours, maybe even the last 6 hours. It's wonderful to see all the support across the entire law school. This is really an event for our law school and every one of us. And I'm very grateful to be a part of this as well. Welcome to all the students. Welcome to all the staff and all the faculty. A very special welcome to our incoming students. We really look forward to seeing each and every one of you in the fall. I can't wait to talk with you more in our class. We're very honored to have you and welcome you to our family. So my name is Cliff Villa. You could probably see in a corner somewhere. If you don't know me already, I, among other things, teach constitutional rights here at the law school. And I tend to think of, and as 1L students do, you see the world and then you start to think, oh, I see a tort. And I see violations of constitutional rights happening in every direction. And at some point in the summer, faculty are thinking, oh, and somewhere on our syllabus, we're going to find a convenient place to put this issue. And we'll talk about it then sometime in the middle of October. But there are moments when we realize we don't have that time. We don't have the luxury to not talk about posse comitatus when it's all over the news this week. If you're not familiar with the tradition of the teach-in, it comes to us from many places, but one of the places it comes to is from the tradition of sit-ins as a form of protest in the 1960s, sit-ins in lunch counters in the South, sit-ins in the corporate offices, sit-ins in the university president's office. Sitting is a form of speech, like shouting, like kneeling, like teaching. Speech includes not just the ability to speak, but the ability to listen, the ability to learn. We are all engaging in very important acts today. We're going to use all of those rights. We're going to talk about those rights. We're going to talk about many questions that we have heard from students, from our parents, from family and colleagues all over. We hope to answer some questions today. We hope to hear more questions and start to think about how we might begin to address them. But we know that we no longer have the luxury of simply making this an item on a course syllabus. The murder of George Floyd has demanded a response, has triggered a lot of unanticipated counter responses. I want to say that one very important thing for our discussion here is a safe environment. You've all made it through the waiting room now. And unfortunately, there are conditions where we have to take extra precautions. You're probably all on mute. The speakers will have the ability to speak when it is time. For those just watching, we'll be monitoring the chat. And when we're done, we will have 6 presentations from faculty. When we're done with faculty, we will have an opportunity for questions and answers. And then perhaps most importantly, we will continue into breakout rooms, which we will attempt through the magic of Zoom. So if you have a question along the way, please just put it in the chat and we'll try to come back to that. If we can't answer it here, we'll find some forum for that. So we will have a series of 6 faculty presentations. We have some commenters too. Presentations will be on the order of 10 minutes or less. I will be monitoring just to make sure that we continue to move forward. We'll have a period of Q&A and then perhaps a period of 30 minutes for the breakout sessions. We really want to respect people's time as well as give them opportunity to talk. But we hope to be really moving forward at about 1 o'clock and thinking about what else we may need to do beyond that. So at this point, as people continue to move through the waiting room, and we really appreciate everybody who is joining us here and ready to engage in perhaps difficult conversations. We really appreciate your courage in all of that. I'm going to hand it over now to student Nikki Berry, the current president of the Black Law Students Association, and she will welcome you as well. So, Ms. Berry. Nikki, if you are here, I can't hear you yet.
How about now?
I just heard you. Yes, please.
Hello, everyone. Thank you for joining us today. Thank you, Professor Villa, for getting all this organized for us and making it come to life. I'm Nikki Berry, the newly elected president, as Mr. Villa said. The purpose of this teach-in today is to engage in critical discussions that we need to have in order for change to happen. We're here today to talk about the lived experiences of Black people. In 1964, the Civil Rights Act was passed, but it wasn't without much suffering and even death of many of Black people. Yet today, we're still here fighting for these civil rights that we thought we had years ago. While many people are affected by racism and injustices, this is a Black issue. Anti-Blackness appears throughout our legal system, and this is not okay. Many of us came to law school wanting to help people and make a difference. But the question is, what kind of difference are you going to make? We're all being equipped by these awesome professors in our externships and our group organizations with the tools to make a difference, to make a change in our legal system and our society, to make it better, make it equal, make it colorblind, make it just. Finally, I would ask that you all please join me in taking a moment of silence to honor the life of George Floyd and the countless others whose life was tragically brought to an end because we're still living in a world with systemic racism and inequality. Thank you. And thank you to all the professors that are here today to talk about this very critical topic we've got going on today.
Thank you. Thank you, Nikki. I really appreciate those words and all the help pulling this together today. It's really appreciated. At this point, we will begin some short presentations from faculty and friends. I also want to add that we are recording this portion of the program. It will be available, among other things, as a YouTube link. We will not be recording during the following Q&A sessions and the breakout sessions to encourage private and confident and comfortable conversations. So at this point, I would like to introduce Leon Howard. He is the legal director of the ACLU New Mexico. He's also one of many distinguished graduates of this law school. We are very fortunate to have him here. And Leon, when you're ready, please take it away.
Thank you for having me here today. It's good to be here with the UNM School of Law family. I think it's tremendous that your professors are thinking about you in this time when we're all hurting. I know it's been heavy for me personally, and spent some time crying and raging and everything in between. The moment, the time that we're working in right now means that many of us are at home with our kids. So if you hear children in the background, of course, now that I'm talking, she's becoming more vocal, and I just have to deal with that. It's a thing for every Zoom call lately. I'd like to hit on a few things. One, the context that kind of brought us to this explosion point, to the ACLU's shift to racial justice work, and then our traditional role in protecting First Amendment rights at all costs, and leave you with some things to think about on racial justice and the rub with free speech. First, with the context we're in and the moment we're in, I believe we've come to this explosion point because we've seen through the COVID crisis, many systems failing Black people on display. And we've seen the healthcare system that ignores Black people in so many ways, and then the COVID outbreak negatively and disproportionately impact Black communities. We've seen schools close down, and that lead to many Black children going without meals, Black children without adequate access to tools at home that could help them continue their education online and otherwise. And then the legal system, the criminal system failing Black people. A no-knock warrant led to the death of Breonna Taylor unnecessarily. Obviously, George Floyd, ex-cop, chase down and murder Ahmaud Arbery. And you know, it took a lot of pressure from the community to bring charges in these situations. And this system that is operating and negatively impacting Black people, you can point to so many things historically. One thing that I like to focus on, because in one other capacity, I'm the co-chair of the Committee on Diversity in the Legal Profession, is that the legal profession is still among the least diverse professions in the country. In 2007, 4% of attorneys are Black, 4% Latinx. And 2017, the last time this information was updated by the ABA, that number rose by 1%. 5% of attorneys in the country are Black, 5% Latinx. So this necessarily means that there's underrepresentation of people who come from backgrounds most negatively impacted by the criminal system and the legal system at large. And ideally, in some ways, the legal system, in our most idyllic vision of that, could be a watchdog for some of these other systems, could be a watchdog for the healthcare system, the education system, but we need representation in our own capacities to put attention on those things. You know, and while there's huge structural changes that are needed, there are some small steps that come to mind for students, for all of us. And one thing that I think a tangible next step you can take, and I don't mean to put Professor Sonia Gibson Rankin on the spot, but she was a mentor to me, and I teach a race in the law class on main campus, and I know she teaches a race in the law class at the university. And that's an important class. I mean, it's not crazy to think that that class should be mandatory. Just beyond our constitutional law and our civil rights law and race in the law, you can learn specifically about the legal system and the history of the legal system and how that's been at times designed to operate against Black people, and how some of those laws are still operating against Black people. Just this week, I learned that there's going to be a bill introduced that would do away with qualified immunity, which is something in civil rights law that's a huge hurdle. I mean, we could spend a whole semester talking about qualified immunity. And you know, like in the legal system, having race in the law is a mandatory bar topic, a mandatory class for students. Things like that are small steps, tangible steps that we can take. Over the kind of past 10 years, I was a staff attorney at the ACLU 10 years ago, and I came back 2 years ago as the legal director. There's been a shift in the ACLU, the biggest civil rights organization in the country, with affiliates in every state, to focus on racial justice work. And we have a big wing, so to speak, in the national office focus on racial justice. I know, and what can that look like? It's cases you wouldn't traditionally think of the ACLU being involved in, but the ACLU currently on a national level is involved in a case against Comcast on behalf of Black-owned entertainment networks under Section 1981 for inability to contract and for Black-owned entertainment networks to be on Comcast's platform. That's something you don't traditionally think of when you think of the ACLU, but it is racial justice work. Locally, in the last 2 years, we've, at the ACLU of New Mexico, completely filled our docket with racial justice cases. Stemming, you know, we have a case on behalf of a Native American student who was called a bloody Indian by a teacher. We've represented 2 African-American patrons in convenience stores, one who was called the N-word by an employee, the other who had the cops called on him when he was perusing items for being suspicious. And then we've represented Black people in Fourth Amendment cases. And the Fourth Amendment is an interesting construct when you look at how these cases read. If you read a Fourth Amendment case, a lot of times it's stripped of race. You don't know what race the cops are, you don't know what race the clients are, and that's something that has to change. And when I write complaints, when the police execute a warrant in Kirtland Addition neighborhood, that's the only Black neighborhood in Albuquerque, or one of the only Black neighborhoods in Albuquerque, and the cops use offensive language about the neighborhood, you know, I make sure that I'm doing my job to bring color into these cases. And so we're doing that work, and we're also in our traditional role of protecting the First Amendment. So right now, in this current moment, our national office is representing reporters who are arrested in Minnesota while covering protests, representing people who were tear gassed to clear out a pathway for the president to do a photo op in front of the church. And we also recently, ahead of Charlottesville, represented a group of white nationalists to allow them to protest, which in Virginia, which led to what we all know was kind of the last big moment of racial tension in our country, and that caused a lot of hurt and pain, which has caused us to reflect on how we view our First Amendment work. And some of the tangible steps we've taken is considering whether or not the group is committed to nonviolence before we represent them. Could they obtain representation elsewhere? And one would the issue actually be pushing the law in a direction that is favorable to the protections for people? And so those are things that we've put in place to make sure we can still stay honest to our racial justice work and our First Amendment work. And I only have a minute left, so I just want to leave you with a thought on racial justice and the rub with the First Amendment. And so one way to think about the First Amendment is you protect all ideas because, you know, we like to protect our free marketplace and allow harmful ideas to be killed in that free marketplace. The second way to think about it is some speech so harmful that it should be suppressed? And if your answer is that the first option, that harmful ideas can be killed in the free marketplace, then you have to know that that leaves people of color trusting a system that has historically failed minorities, and protecting some types of harmful speech can suppress voices of minorities, create further distrust and division in communities of color between the legal system and groups like the ACLU who defend that harmful speech. So thank you for having me here today. I consider the School of Law, UNM School of Law, my family, and I'm happy to be here, and it's still fresh, and I really appreciate that you guys are doing this for the students.
Thank you, Leon. We really, really appreciate those comments. I'm now going to introduce Professor Miriam Aranjani. She teaches constitutional rights with me, criminal law. She has been the longtime director of the Marshall Brennan Project, which among other things helps teach high school and particularly disadvantaged high school students about their constitutional rights, which is so important at times like these. Miriam? You're still on mute. There you go.
Thank you. Can you all hear me? Okay, I see some nods. Salam alaikum. Ismi man Maryam Aranjani hast. I am an American of Iranian descent. I'm a law professor who, as Professor Villa just mentioned, teaches criminal and constitutional rights, and a longtime supporter of the Marshall Brennan Constitutional Literacy Project, which I'm always happy to talk to anyone about. I am a wife and daughter of immigrants, and I'm the mother of an interracial child. I stand in solidarity with Black Americans today and every day. I've been asked to comment today on criminal procedure aspects of the George Floyd case. But before I do, I just want to echo the sentiments of the earlier speakers, Leon, Nikki, and Cliff. I'm so grateful to be a member of this law school community. I've been lucky enough to be in touch with friends and colleagues, PDs, prosecutors, law professors all over the country this week. And I have to say that not all institutions have stepped up in the way that ours has. And it, from the leadership to the faculty to students, I think there's no doubt that we are all deeply committed to justice and making our community, the national community, and the world community more fair. So my contributions are going to focus on two different areas. One is the charges against Officer Derek Chauvin and the 3 officers at the scene. And then I will talk just briefly about the Supreme Court cases related to the use of excessive force which I hope will help ground the presentation by Dean Mathewson about what's going on here with APD. So in terms of the charges, many of you know, and I'm going to assume, you know, with teach-ins, we want to make sure that everybody's on the same page in terms of basic information so that we can then engage in more difficult conversations. So some of what I'm sharing, I think, will be familiar and to some and not to others. Derek Chauvin was fired immediately along with the other 3 officers at the scene after the horrific actions that they took that led to the death of George Floyd. Initially, the Hennepin County DA charged Officer Chauvin with 3rd-degree murder and included a lesser included charge. Earlier this week, though, Attorney General for the state of Minnesota, Keith Ellison, amended the charge to include 2nd-degree murder, a higher charge. It's not typical that AG offices get involved in these types of cases, or it hasn't been, I should say, although this is one of the calls for reform that have been recommended and they're being implemented hopefully across the country, which is that, you know, local DA's offices, certainly there's at least an appearance of impropriety when they are prosecuting their own, so to speak, you know, the law enforcement officers in these kinds of cases. So the idea is to remove the cases from their jurisdiction. And so anyway, in this case, Attorney General Keith Ellison has taken over, although he is working in collaboration with the local DA. Now, many people say, why haven't there been charges of 1st-degree murder against him? Attorney General Ellison has noted that it's an ongoing investigation and that charges may change if, you know, the evidence comes before him that he thinks will merit a charge of 1st-degree murder. 1st-degree involves premeditation, which I think many believe could, you know, on the basis of what we've all seen, which is not all the evidence, but we know that premeditation may occur in just the blink of an eye. It doesn't involve long-term planning necessarily. I mean, it may, but it can also happen very quickly. So many have argued that they're, in this instance, because of the fact that Officer Chauvin's knee was on Mr. Floyd's neck for so long, after he was being told, "You're hurting me, I can't breathe," he continued to do so, that he was then sort of premeditating the murder. But anyway, at this moment, we don't have a 1st-degree charge. 2nd-degree murder in Minnesota can be intentional or unintentional. In either case, the punishment is up to 40 years in prison, which is significantly more than the initial 3rd-degree charge by the local DA, which carried only a sentence of 25 years. It looks like there's enough evidence here for intentional murder, which involves causing the death of a human being with intent to affect the death of that person or another, but without premeditation. Unintentional 2nd-degree murder involves causing the death of a human being without intent to affect the death of any person while committing or attempting to commit a felony offense. Again, the evidence is evolving, and I think it's important to note, you've got to understand that in these cases, despite overwhelming evidence of police misconduct, juries tend not to convict police officers. It's happened only once before in Minnesota that a police officer has been convicted of misconduct of this type. And there are many reasons for this. The first is, and Attorney General Ellison talked a lot about this in the news this week, you know, in court, often credibility questions are resolved in favor of law enforcement. We're taught to believe the police. We're taught to call them when we need help. And jurors and judges, you know, have this bias that the police are telling the truth, which is sometimes the case and sometimes it's not. We also know another reason for juries tending not to convict police officers is that and I'm going to talk about this in just a minute, the law authorizes use of force beyond that of ordinary citizens for law enforcement. There's also lots of political support for the police. And, you know, lots of politicians want their support when they're running for office. So the idea of, you know, holding them accountable is a tacit no-no. I'm hopeful that these reasons will change because of what's happening right now, at least some of them. I also just want to say one last thing about Derek Chauvin. If you haven't noticed, he's had 18 previous complaints against him, according to what's been reported in the news. So this is not somebody with a clean record. It's somebody who clearly has a problem with African Americans and other, people of color and vulnerable populations. Now, in terms of the other officers at the scene, they weren't initially charged, but Attorney General Ellison has charged them now. Officers Tao, Kang, and Lane have been charged each with aiding and abetting second-degree murder while committing a felony, and with aiding and abetting second-degree manslaughter with culpable negligence. And in Minnesota, both of those charges are categorized as unintentional felonies, making it a little bit easier to make the charges stick. And you know, prosecutors are, especially in these cases, even if a prosecutor is very serious about holding law enforcement accountable, they also are concerned about making sure that they have charges that they can prove again, with juries and who are biased, as humans are, and some more than others. So I just want to say a few things about excessive force, the second area of criminal procedure that I've been asked to discuss today, and I'm happy to take more questions during the Q&A. Excessive force refers to situations where government officials legally entitled to use force exceed the minimum amount necessary to diffuse a situation. And it comes up in many different contexts, the idea of excessive force. There are two constitutional bases of support against the use of excessive force. They are the Fourth Amendment's reasonable search and seizure requirement and the Eighth Amendment's prohibition on cruel and unusual punishment. There are two cases I just want to mention, a pair of cases in the 1980s that govern this area of unreasonable force. The first is Tennessee versus Garner, a 1985 case in which an unarmed, non-threatening teenager was shot in the head while fleeing a house that police suspected he had burglarized. In that case, the court found that the police used excessive force in violation of the Fourth Amendment. And in that landmark case, the court held that deadly force in particular, and I'm going to talk in a minute about the use of force spectrum, because unreasonable force is not just deadly force, but in this case, deadly force can only be used during an arrest if two conditions are met. One, it's necessary to prevent the suspect's escape, and second, that the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. Those are the circumstances under which the Supreme Court has held deadly force can be used. It's pretty clear in this case that's not what happened. And in many of the cases in which African Americans have been killed by law enforcement officers, thanks to the video footage that we have, we know that that's not the case. Now, in terms of the second case, Graham versus Connor, a 1989 case, there the Supreme Court held that the right to make an arrest or investigatory stop necessarily carries with it the right to use some degree of physical coercion or threat. So in other words, the court expanded the use of force in this case, acknowledging that there are times when officers need to use some degree of physical coercion or threat. But in that case, the court said that the degree of coercion or force used has to be proportional to the threat, and it can only escalate in response to the threat. So the examples in terms of graduated methods to diffuse a situation that are allowed physical presence, an officer just using their mere presence, stopping somebody by standing in front of them is the first sort of least intimidating use of force. Next would be verbalization, using verbal statements from non-threatening requests to direct orders. So please, please, you're in an authorized area, or we would like you to sit down at this moment and put your hands behind your back. Those would be examples of verbalization. The third level in this continuum is empty hand control, which involves using physical bodily force through grabs, holds, punches, or kicks. Next are less lethal methods, including using weapons like batons and chemical sprays, tasers, police dogs, which we've seen happening all over the country this week. Finally, during the protests, lethal force, which is of course what happened in this case, although typically those involve firearms. Now, in order to be considered reasonable and compliant with the Constitution, the US Constitution, the use of physical force must stop when the need for the force ceases, such as, for example, when a suspect is successfully restrained or a situation has de-escalated. So I think it's pretty clear in this case that those conditions were not met. And I just want to end with this before I pass the baton to Dean Mathewson to talk about the use of excessive force and Albuquerque police. As a 1L criminal law professor, we have lots of conversations about how to teach the law, and there are conversations really around the country about the idea of focusing on teaching the law as if it is objective. And frankly, I don't know how you could teach any, I certainly couldn't teach criminal law without talking about race. And I think the incidents that have happened, for decades, but certainly in the last week implicate, and what Leon mentioned as well, in terms of the importance of understanding race in the law and the way in which racism is deeply embedded in American law. I just invite you, if you disagree that you don't know how race influences teaching or learning of the law, I implore you, I really encourage you to try to educate yourself, try to learn about how that might be. And with that, I just want to thank everyone for your participation. I look forward to the Q&A. And Dean Mathewson, you're next.
Good morning. Thank you for asking me to be a part of this. For those of you who do not know me, I was active on the faculty for over 35 years and retired about a year ago after becoming dean along with Dean Perea. But I'm going to start today the way I started at the Albuquerque Human Rights Board meeting on Monday night. I love you. I love all of you. And I got the idea, just move to just let people know that I love you. Because I received a Facebook post from a group. I'm in a Facebook group, and somebody I didn't know posted. I got this big sign that said, "I love you." And I was like, okay, who is this? But below it said, "You probably don't know me, but I don't know you. But I figure if people can hate for no reason, I can love." And so I love you. That's where I want to start. I have been involved with the APD consent decree now for almost 6 years. I got involved through a woman named Jewel Hall. She's been very active locally. She's now over 80 years old. But I first encountered her when she was forming a nonprofit with some other school teachers, and they came to the clinic, and the business and tax clinic did their help them get their incorporate them and get them their 501c3 status. She has been very active, and when the APD over a 2-year period killed over 24 people, She was among the activists who pressured the city to call in DOJ and was pressuring DOJ to come in and investigate. And they did. And so I became involved, but I'm a corporate lawyer. So this is territory that I didn't know, and I learned a lot. So I want to tell you something about the process here and police reform. There is a statute. It is known as the Rodney King statute, in fact, because the Congress enacted it. I think it's the Violent Crime Control and Law Enforcement Act of 1994 that was enacted after the Rodney King riots. And that statute authorizes the Department of Justice to obtain equitable relief or injunctive relief when it finds that a law enforcement agency has engaged in a pattern of practice of unconstitutional policing. And so the process begins. DOJ has to make a finding. President Obama used that statute to very aggressively pursue police reform. And so the Department of Justice began investigating cities where they had incidents occurring. In those cities, DOJ would come in and they would investigate, and then they issue a findings letter. So they were pressured to come in here and investigate. And they did investigate, and they made findings, a very scathing findings letter, that APD had engaged in a pattern and practice of unconstitutional policing. However, when we talk about unconstitutional policing, Leon Howard, who was a former student of mine and whom I got involved in the process, talked about the Fourth Amendment. That's excessive use of force. In most cities, there is a Fourth Amendment and I was just there are Fourth Amendment and 14th Amendment violations. In Albuquerque, there are only Fourth Amendment violations. The findings were only on the Fourth Amendment. There was no finding of racial bias, and therefore no remedy within the agreement that was settled, that they reached. And so that's the process. DOJ makes the finding, and then it negotiates with the city to come up with a consent decree. And so to address the pattern and practice of unconstitutional policing that they found. And that was where I came in, that Ms. Hall got me involved. And along with Representative Antonio Maestas, who was also a former student. And we've put together a team of law students to do these community education workshops about the process for negotiating the settlement agreement. The statute there's not very much in it. It does not provide anything about community input. And so when they came in to negotiate, they were negotiating in essence, but it was just between the DOJ and the city, and all the community activists who were involved were on the outs. And so the idea was to try to find ways in which the community could become involved. And that was a part of what we were doing. We looked at the process. We went through a step-by-step in all the places where the community could come in and have some input. One of the things we looked at in terms of other cities, some cities use something called a fairness process that you see in a class actions lawsuit, where the judge has to make hold a hearing and have a determination that the settlement was fair, reasonable, and equitable. And so we pushed to have such a hearing here. It was granted. The parties asked for it and the judge granted it, but in order for community organizations and activists to participate, they had to be represented by counsel who filed an amicus brief on their behalf. So they had to find free lawyers. So Representative Maestas and I wound up representing several of the organizations that we had done these workshops for. So that process continues. And the idea being, again, so that DOJ makes findings, and then they negotiate a settlement agreement to bring about reforms. So they address the use of force issues, but here mental health and homelessness were big issues. And so there are provisions in there to address these. While we did not get a prohibition of racial bias in the consent decree, what we did get them to do was to collect demographic data and report it. So paragraph 298 is the big section on that that requires them to collect and report data across a number of variables. It's race, it's gender, age, area command within the city, type of use of force. All of that is required. It's been almost 6 years. We just really got our first set of data. And we are working with graduate fellows at the Robert Wood Johnson Center to have them analyze it for us. And with the hope, and what we believe is that it is going to show racial disparities in the data. So it's been, I mean, just in terms of the process here, we had the fairness hearing. All of these organizations, there's several amici groups that participated in the fairness hearing, and they have kept us involved. So when the monitor has to issue periodic reports, and what Judge Brack, who was the original judge on this, did was he required the monitor, he held a hearing on the report rather than just have the monitor file the report. And so we regularly appear in court when these hearings are held, but the process requires the amici groups to submit a notice letter in advance to the parties about what our concerns at that time and what we would like to talk about. And then we designate who's going to actually speak in court. The big issue now, again, it's been almost 6 years now. The administration has changed, and the Keller administration has been much more receptive, and just in terms of trying to participate and comply with the consent decree. But you may have seen recently that the city filed a motion back in February to move from monitoring by the federal monitor to self-monitoring for about 25% of the provisions. And that's a part of it, is there's no explicit provision in the consent decree for that, but it does allow them to amend the consent decree. But that motion is still pending. The amici groups resisted when it was first announced. And so there is the hearing on that motion is scheduled for August 28th. For our amici group, the race has always been a part of it, but our view has been it's not just about bad cops, it's about a culture. And so what we have advocated as this request came up, this motion came up, to move from have those provisions move to self-monitoring, that we wanted, I mean, that's a huge principle for my group because they asked to have the federal monitor come in. We want a federal monitor. And so moving away from that is a big step. It would come at the end when there's been full compliance, but this is having something happen before that. And what we've asked is that any deviation from the federal monitor should be accompanied by not just technical compliance with the decree, but we want to see something, a transformation of culture. We need to see things, some sort of transformation that we can touch and feel, but we want to see something like that. That we now have a new judge. Judge Browning is now the judge. And when we raised this in the last hearing, Judge Browning asked the city, asked DOJ, the police union, and the amici groups about transformation in culture. What would that look like? And so that's something that we're asking people, because we want this transformation, but we need to be able to articulate what would, in terms of police reform, what would a transformation of culture look like, because that's what we want to push. Almost certainly, race has to be a part of that. Even though it's not in the consent decree, you can't change the culture of the police unless you take race into account, particularly in a city with the demographics that we have. I've learned a lot, and my 10 minutes are probably about up, but a couple of things just in terms for me. We have advocated that the process be opened up to allow input by community organizations and activists that are not represented by a lawyer. Our group has maintained and been very adamant about this. They are active in the community, but they were not elected to represent the community. They do not speak for the community. They speak for themselves. And there are these other groups that have concerns. They may be similar, but they may have different. And we think that there should be a place for them in the process. Watching what's happened now with George Floyd, Breonna Taylor, Ahmaud Arbery, who's not, although wasn't police. This transformation in culture, we sort of hear that, yes, transforming a culture takes time. I think time's up. We need to fast track this transformation in culture. And we need to see some progress on that now. It's already been almost 6 years. So we need to have something happen a lot sooner. I would say that the Graham's, one of the things I learned about the Graham-Connor legal standard, just my observation, it allows too much error. That standard is not just a threat to the people, civilians that they encounter, it is a threat to police. I have started to look at friendly fire police cases, because once the shooting starts, it starts, and police sometimes get killed. And it is that Graham-Connor standard that allows the degree of error, and which is a threat to the police as well. I would say I am heartened watching the crowds, the protests, how diverse they are. A generation in this country is going through something together. And so when I see it's not just Blacks, but non-Blacks, whites, Hispanics, Asians, the people who are out there, they are going through this together. And I think that this is the opportunity, the moment to see something. And if nothing else, it just seems to me that one thing they can do is to call off the police. The police are there to protect. And if you sort of survey the public, about half of Albuquerque sees nothing wrong with the police. They like what they're doing. And we need that group to call off the police, those who are protected by the police, in essence, to call off the police on those whom they just police. I'm going to stop there. I think I went over my 10 minutes.
Thank you, Alfred. We are very, very fortunate to have you and so many incredible people continuing on the faculty in one way or another. So very, very grateful for your comments. At this point, I'd like to welcome Professor Josh Kastenberg. We have lots of different kinds of expertise on the faculty. Among other things, Professor Kastenberg has a lengthy history as a military lawyer and a military judge. When you see lots of questions this week about use of posse comitatus and the Insurrection Act and other things, it's really great to have real experts on our faculty. So welcome, Professor Kastenberg.
Thank you. And I want to add to what every speaker has said before me, and that's to say thank you to all of you. Thank you to both our former dean, Alfred Mathewson, and our current dean, Sergio, for showing leadership. Cliff, to you as well. And Nikki, to you for being on the front lines. I think of the fact of this, I have to put it out. I grew up in privilege with a dad who was a professor who I absolutely adore. But I have both great hope and great consternation for our future. And we all see things from the point where we cave. So I like where we've been. So I'd like to share with you a couple of things and encourage you to, before getting into the Insurrection Act, and encourage you to think, you know, we used to grow up saying, think globally, act locally. So in the law, think globally. When President Trump first came into office, he played to his base on two significant military justice issues, which caused me and my peers, not just lawyers, but there was a time when I held an M16 before I became a lawyer. Me and my friends who served on that side of the military as well. And one was his treatment of Bowie Bergdahl, which I won't get into too much, but I do represent him. And we had an interesting argument earlier this week. And the other was his pardoning and releasing early from prison soldiers who were convicted of war crimes during the Iran-Iraq conflict. Everyone he granted a pardon to was white. And of course, the victims of their crimes were Iraqis and Afghanis. And so you could say globally, they were persons of color. And this played wonderfully to his base. I bring you this point to say that war crimes and war crimes prosecution, in particular, were a uniquely United States institution, which began under Abraham Lincoln, were forced into the Nuremberg context by good thinking people in the United States, and were insisted upon in the Hague Conventions and the Geneva Conventions by not only Americans, but also people concerned with fairness and free treatment of innocent persons around the world. And when I saw that, I thought, good God, he's going to misuse the military in other ways one day. And of course, you're going to hear people say, oh, that'll never happen. So let's talk about the Insurrection Act and what has happened last week. In this context, whatever we may say about the framers of our Constitution, and they were slave owners, and many of them were slave owners, and they talked about freedom, but they really talked about freedom for some and not for all. Certainly women weren't going to get the vote. And some of them didn't even like non-property owners getting the vote. But one thing they brought over with them from the Whig tradition in England was a fear of standing armies. And the reason they brought that fear with them is that a standing army could be used by a president seeking to become a dictator. And to the point where most of the framers of the Constitution didn't want one, were opposed to one and wanted to place it in the Constitution. But Alexander Hamilton got his way, and there was a very small standing army. The founding fathers wanted to rely on militia, which is my argument, and perhaps Professor Aaron Johnny's argument to why the Second Amendment exists. There is that clause after all. And that had to do with the British peasant model of calling up white males from around the counties and saying, okay, the British are coming, or the French are coming, or we're going to go off and fight Native American tribes, get your rifle and go. And so there was an idea that people tied to their community as part of the militia would never be a threat to the Constitution or liberty. And then reality set in. The Civil War occurred, World War I occurred, the Cold War was in full swing, the United States became a superpower, the militia converted to being a National Guard, to the point where in the 1950s, military and political science scholars would say, well, if the founding fathers saw what we were like today, they wouldn't have had those fears. Not so. But when the president ordered, or I thought of ordering aloud, the military to suppress both legitimate protests, which is the vast number of protesters, and then under the guise of this alleged threat Antifa, which seems to be more like right wing and people masquerading as that group, if it even exists. He was using the military, threatening to use the military for something the military is not trained to do, which is police. The military is trained at the end of the day to kill, and kill from a faraway distance. That's the idea of having the military police a city in the United States is antithetical to the Constitution of the United States, such that in 1807, Congress felt worried enough because of internal rebellions like the Whiskey Rebellion and Shays Revolt to pass the Insurrection Act, which made it unlawful for a president to order the regular army in anywhere unless a governor or a state legislature couldn't handle a situation through calling out their militia. Now, keep in mind, militia is like sheriffs in that area, the predecessor of the National Guard. The National Guard is different. They are trained in policing, but the military is not, other than military police. But by the way, military police are trained to do things like protect nuclear stockpiles, not necessarily arrest people. Those are fundamentally different as well. Now, there have been instances in American history where presidents have followed the Insurrection Act prior to the Civil War, when the Posse Comitatus Act modifies it after the Civil War. One is, and I think Professor Sherry Burr will articulate this better than me, one of the worst human beings ever to reside in the White House, John Tyler, had an opportunity to call the army into Rhode Island. There was a rebellion in Rhode Island in 1840 that threatened to overthrow the government. It's a complex story as to why. The Rhode Island governor asked Tyler, "Can I have your help and get the army?" And Tyler said, "No, you're on your own." Tyler was concerned about looking like a dictator or taking a step. Maybe it was the only right thing he did in office, but he did it, and created a precedent that presidents will not use the military, the active duty army in the United States. And of course, the Civil War changes that construct because it's a war and it's fought on American territory. But in 1877, partly in a buy-off to Southern whites, Congress passes the Posse Comitatus Act, reaffirming that the Insurrection Act means something. What the Insurrection Act means under the Posse Comitatus construct is, short of a foreign invasion or the collapse of a state government, the active duty army cannot be used in a policing operation in the United States. Now, there were some labor strikes where President Grover Cleveland called the army into Chicago, for example, during the Pullman strike, but that was only to protect the US mail. It was only very narrow and lasted for a couple of days. Another one is there was a massacre of Chinese railroad workers in Rock Springs, Wyoming. And Cleveland also sent the army out there to create law and order. Of course, Wyoming wasn't even a state when this occurred, so there was some argument that he wasn't breaking the Posse Comitatus Act. But the army was used to, at the behest of the railroads that were looking for cheap labor, not out of humanitarian grounds, but to police, now domestically. Now, having said that, I know I'm in a short 2-minute warning. Where are we with the president and his use for the army, and what's happened, or the military and what's happened? And I'll boil this down to two things. I gave this quote to the Kyoto Shimbun the other night. The first is that the United States Army is not the Reichswehr, which was the army of Germany during Weimar, where it was distrusted by the government and really wedded to the idea of bringing the monarchy back. And so Hitler was sort of second best. The army of today is steeped in the Constitution. And so no doubt, General and the Marine Corps, Air Force, and Navy, no doubt General Mattis and Admiral Mullen are speaking on behalf of active duty generals that can't speak for themselves. On the other hand, a president who would seek to seize power, the best vehicle to do so in a situation like this is to use the one institution that's subject to his command and control, and his service members have to follow their order unless the order is illegal. And believe you me, White House counsel and Attorney General Barr will tell the military the president's orders are legal. What happened, and this isn't hyperbole, although you're free to disagree with me, what happened the other day when the president walked from his bunker, symbolically, I would say, for the wrong reasons, to the church for the photo op with General Miley, who, if he was duped into doing so in his combat fatigues, ought to resign in protest, indicated to the people of this country that his vision of America, MAGA, et al. And his supporters are above the Constitution of the United States. Steeped in pure questions of racism, I will tell you that in my lifetime, and again, you're free to say this is hyperbole, my own opinion, this was a far more dangerous moment than when President Nixon ordered an invasion of Cambodia and the nation convulsed 50 years ago, leading to things like Kent State. And on that point, one final thing and comment is, when can the courts intervene? Well, unfortunately, that's an open question, because in Schurer versus Rhodes, an appeal which arose out of the Kent State massacre, the Supreme Court said, well, the governance of the military by the executive branch is really a matter for Congress. It presents a non-justiciable political question to us, which is exactly what Chief Justice Taney said in a lawsuit that arose from the Rhode Island rebellion called Luther versus Borden. And I suppose my contribution is this. I won't put Mattis on a heroic pedestal or anybody else, but my contribution is this. We need lawyers. We need people peacefully demonstrating. We need a white society giving a new commitment to civil rights. And we also need to encourage those people who say, my vote doesn't matter, or I don't like the other guy who's running for office, to get out there and vote and make a change and make a statement. Because without that, there really is the possibility of a tyrannical future, which will crush us all. And I'm going to yield my time back on that not so happy note to Professor Villa.
Thank you, Professor Kastenberg. Well, we have some difficult truths to speak. We appreciate all of your particular expertise in these concerns. I'm now going to welcome Professor George Bach to speak. Professor Bach teaches constitutional law, teaches many other important subjects, including evidence trial practice, also extensive experience as a civil rights lawyer himself, and another very distinguished graduate of the same law school. So George, are you there?
You bet. Thank you so much, Cliff. And I want to echo the thanks to Professor Villa and all of the panelists, to Dean Pareja and everybody for being here today. It's great to just see you, and it's great that everybody's got their camera on, because it's nice to see you during these difficult times. Leon mentioned qualified immunity, and it is the bane of existence of civil rights lawyers today. And this is on the civil side of remedying constitutional violations. And so I'm not talking about the criminal prosecutions against officers who have committed heinous acts, but rather lawsuits for damages against them. And there's two primary vehicles. And Leon's correct, we could spend a semester on this, and I'll do what I can in 10 minutes. The primary vehicle for lawsuits for damages, and that includes compensatory and punitive damages against state law enforcement, is going to be 42 U.S.C. 1983. You've probably all heard of Section 1983 lawsuits, or you will start hearing more and more about them for sure. And that's one of the Reconstruction statutes. It was adopted in 1871, and it was broadened by the Supreme Court's interpretation of it in the early 1960s. And it has gained greater use since that time in the past 60 years, enabling individuals to sue officers for violation of their constitutional rights, such as an excessive force claim under the Fourth Amendment. And then there's an analog, which is a judge-created cause of action, which is a Bivens action that allows people to sue federal officers who abuse their constitutional rights. So you've got two avenues to get damages, and there's deterrent value in that, in addition to compensating victims of excessive force. The punitive damages also hopefully deters future conduct. Well, one of the reasons why we're talking about this today is one of the reforms that has been talked about is to eliminate a defense in those actions known as qualified immunity. There was an editorial by the New York Times editorial board, a couple of opinion writers in the USA Today. The Denver Post had a column yesterday on trying to reform and eliminate qualified immunity. So what is qualified immunity? Well, if you bring a lawsuit for damages against officers who have violated your constitutional rights, like I would presume the family of George Floyd will do and should do, the officers can raise a defense of what's known as qualified immunity. And qualified immunity says that officers are immune from suit for civil damages. They're immune from the very suit itself for civil damages, unless the plaintiff establishes that the officer was violating a constitutional right. And then here's the real kicker these days, and the law, that is the constitutional right, was clearly established at the time of the incident. There must have been clearly established law. So this doctrine was developed by the court in 1967, and there's a bunch of different rationales for it. One of the rationales includes the expense of litigation if the officer didn't even know that what the law was at the time, if the law wasn't clear. Concern, and this is going to ring really hollow today, the concern about over-deterrence of police officers doing their job. And so the idea is, if the law wasn't clearly established that what an officer does is unconstitutional, they ought to be able to raise that as a defense. And initially it was, for example, if an officer arrested somebody and the law was later found to, the statute was later found to be unconstitutional, the officer ought to be entitled to qualified immunity. But it has gone way beyond that, way beyond that. And now you have justices on the court on both sides of the political spectrum criticizing the doctrine has really divorced from its initial intentions. You have Justice Sotomayor, probably the justice that most frequently criticizes the doctrine, as saying that it's really turned into an absolute defense by police officers. And I'll show you why in just a second. But you also have Justice Thomas issuing opinions saying that, you know, we need to relook at qualified immunity at some point because it's gotten so far from any common law basis that might have been in existence at 1871 that I think we really need to evaluate it. So how has it gotten to be so broad? Well, remember I told you the law has to be clearly established. That, the court has said, that doesn't mean at a high level of generality. Is there a right to free speech? Absolutely. Is there a right to be free from the use of excessive force? Absolutely. But that's not what the court looks at in deciding whether or not a police officer is entitled to qualified immunity. Instead, what they have done is they make it extremely particularized. It has to turn on the specific context of the case. And so the question is not, is there a right to be free from use of excessive force? The question might be, is there a right to be free from use of a baton when unarmed but fleeing from arrest? Or a right to be free from use of a taser when unarmed, when fleeing from arrest for a felony? Or the right to be free from use of a taser when unarmed, fleeing from arrest if you are accused of a felony and you are showing other signs of dangerousness. It all turns on a very, very, very fact-specific inquiry. And what the court has now said is, you got to show us some authority where either the Court of Appeals have repeatedly said that X conduct in a specific context is a violation of the Fourth Amendment, or you don't have clearly established law. Either the Court of Appeals or the Supreme Court must have said very clearly that an action in a very fact-specific context is unconstitutional. And this is the problem, is if you bring a civil rights suit and you have a new set of facts. I was talking to one civil rights lawyer recently who said, yeah, the court will distinguish prior precedent if the prior precedent happened on a Monday and involved an incident that happened on a Monday, and this case involves an incident that happened on a Thursday. And it's not quite that bad, but it's almost that bad. Let me give you a quick example. The Casella versus Hughes case involved an incident where police were called to a yard where a woman with a history of mental illness had a knife and was hacking away at a tree, and her roommate was some distance away. She wasn't threatening police. She wasn't openly threatening the roommate. She just had a knife. And so two of the officers said we should wait and try to disengage and de-escalate. The other officer, Casella, said, no, I don't think so, and used lethal force and shot her 4 times. There was a lawsuit. She survived miraculously. There was a lawsuit brought all the way up to the Supreme Court, and the Supreme Court said, you know, you don't have a case that looks just like this. The case that you're relying upon from the Ninth Circuit, there was an incident where there were bystanders nearby. The person had been physically compliant before they were shot. They had been under police observation. You had none of those facts here. And so how was the Officer Casella to know that what he was doing was unconstitutional? Now you think, based on what Professor Aranjani told you, that officers would just know that. But the Supreme Court, this is the title of the editorial in the New York Times, has let them get away with murder because they require cases that are so close, so similar on the facts, or they say that the law wasn't clearly established at the time. And so that's a problem, because you don't get civil rights suits that even get to go to a jury, because judges will throw them out saying the law wasn't clearly established. You can't show me a case that has such similar facts. And so there's calls for reform. You have voices on the court, and currently there's 9 cases involving qualified immunity that are up at the Supreme Court. We'll find out on Monday if they are going to grant cert to revisit the contours of qualified immunity. They discussed it yesterday at conference. I'm not super optimistic, and the reason is you have Sotomayor, who's pretty consistent, but not perfectly consistent in criticizing the doctrine. You have Thomas criticizing it sometimes Ginsburg, but otherwise you don't have a groundswell of criticism by the court. You have Representative Amash, who is going to introduce a bill, and you have Senators Booker and Harris and Markey, who have introduced a resolution in the Senate calling for legislative action to eliminate the qualified immunity defense. And so one of the reforms that could happen is to make it a little easier to proceed with civil rights suits, to at least get to a jury and not have the suit thrown out because there wasn't a case directly on point previously. If you want to know more about this, feel free to email me. Professor William Baud at the University of Chicago has written a terrific article outlining the history of this doctrine that really deserves more than 10 minutes, but it's one of the possible reforms that hopefully will come out of these tragic events. Thank you.
Okay, thank you, Professor Bach, and you are right on time. That was very impressive, and that was a lot. Really, really appreciate everything you bring here. We have one last faculty presentation today. That is Professor Sonia Gibson-Rankin. Sonia brings so much, of course, to our law school community as well. Among many other things, she really helped us pull together student participation here as well. So Sonia, whenever you're ready, please take it away.
Thank you. I was waiting to be unmuted. Thank you. Good afternoon, everyone. I thank my colleagues and the law school community for being ready to have this kind of a conversation. I'd like to dedicate my comments and this time to actually the memory of George Junius Stinney Jr. For those that don't know, George Stinney in 1944 became the youngest American in the 20th century to be executed at the age of 14 years old. He was playing with his sister in a field. 2 young white girls were killed near where he was. No written confession was ever given. No witnesses were called on his behalf, and the jury took 10 minutes to deliberate. He was so small that they had him sit on the Bible that they brought to his execution in order to be electrocuted to death. His conviction was vacated in December of 2014, 70 years after his execution. And I bring up George Stinney Jr. because it helps you understand that this is not a, wow, I can't believe this is happening in 2020, but it helps you understand that this is a historical practice that has been in place in our nation from that time. So my section to kind of discuss is what is Black Lives Matter. And Black Lives Matter is a little bit different than what you may have studied as it relates to the civil rights movement, which was more centered around organizations or persons who would lead programming. I think it's critical to keep in mind that when Dr. Martin Luther King Jr. was executed, that he had been rated or polled as one of the most hated men in America. So when you look at the response that some might feel to this notion of Black Lives Matter, you can understand where it's centered in some of those spaces. Black Lives Matter is a group-centered model of leadership, and it really took off as a hashtag after the shooting death of Trayvon Martin in Florida. And that's where the hashtag began. And the movement was co-founded by 3 Black female community organizers, Alicia Garza, Patrice Cullors, and Opal Tometi. And after that moment with George Zimmerman killing Trayvon Martin, the movement then began nationally recognized with the street demonstrations after the 2014 death of Michael Brown in Ferguson, Missouri, and Eric Garner in New York City. That has now spread into a larger conversation on the movement for Black Lives, which is a little bit different than Black Lives Matter as a hashtag, that really centers on an idea of Black organizations across the country purposefully working together for specific shared policies and political strategies to deal with the impact of Black lives as they're impacted in criminal justice, in education, in healthcare, and a number of different categories. And so something I'd like you to think about, ladies and gentlemen, as you go into your break rooms and understand what is going on is, why does this feel so complex? And I thank my colleagues for bringing up a lot of critical cases that outline how we are where we are. But at a deeper level, what you're going to remember, of course, from all your studies thus far is what is reasonable, right? This idea of justified force, this idea of behavior and steps that people take. And you can look at it from the stand your ground statute in Florida of 776.012, 776.013, and it defines under stand your ground as the person reasonably believes that such force is necessary. A person is presumed to have held a reasonable fear of imminent peril of death or great bodily harm. You'll remember from studying in TORSA what a reasonable standard person definition looks like, right? This hypothetical person in society who exercises average care, skill, and judgment, who serves as a comparative standard for determining liability. You'll know from US versus Thind for the definition of what is white that the court will determine that white is to be understood in accordance with what the common man believes. And so when you come to Tennessee versus Garner in 1985 that Professor Aranjani raised, you understand that police could only justify using deadly force if the suspect posed a threat to the officer or others. And it is on this basis of a good faith belief. And so this is what you need to think about as you go through your legal studies, is the racialized ideology behind every law and the outcome of the laws that you will be studying and hopefully be agents of change for a better society. Who are these people and how are they to be treated? That's really the foundation of what we're looking at, right? And Chief Justice Roger Taney gave this in Dred Scott versus Sanford, when Chief Justice Taney said, no rights, that the Black man has no rights which the white man was bound to respect. That's the basic ideology. That's why intent becomes so complex. That's why reasonable person standard doesn't look at the lived experiences of people of color in our various communities, and in particular, the distinct impact of anti-Blackness within the law. So how does that shake itself out? It shakes itself out because just in the last 2 years, we have indications of police being called or community activism and executions on Black people doing these kinds of things, studying at their own campus's law library, cheering for their own son at a soccer game, sitting in their own assigned seat on an airplane, building a community garden, moving belongings into their own home, fouling a white man who was playing basketball with the person. wearing socks at your neighborhood pool, wearing a hijab and cotton at a pool, selling water without a permit if you're 18 years old, using a coupon at CVS, pushing your own baby around in a stroller, a 12-year-old cutting their neighbor's lawn, accidentally a 12-year-old getting a neighbor's house wet while using a slip and slide, being the victim of physical assault by your own racist neighbors has had police enforcement on the person who called to say, I'm being racially attacked. Owning your own business and trying to open it up in the beginning of the day, renting an Airbnb, questioning an upcharge on a Waffle House receipt, golfing too slowly has had the police called on someone, drinking wine on a wine trip in a train, wearing too many clothes on an airplane, campaigning while running for office, a 7-year-old who was sleeping had the police called on them, running, going to Bible study at your church, moving into your own apartment. I bring those things up because those are things that are considered the normal course of a basic life. I'm not even going to go into all of the instances of the police being called on Black people that don't even exist. We saw this with Susan Smith, who argued that her 2 children had been kidnapped by Black men, and when in reality, she had driven them into the lake because her boyfriend didn't like them. Before it was over, a group of Black men all throughout the South had been so coerced by law enforcement that they confessed to killing these 2 children that they didn't even know. And so I'm going to take a moment to do something that's probably the most critical, which is to say their names of people who have been executed. Eric Garner, John Crawford III, Michael Brown, Ezell Ford, Laquan McDonald, Tamir Rice, Jerame Reed, Frank Smart, Walter Scott, Trayvon Martin, Tamir Rice, Michael Brown, Philando Castile, and for a young lady whose birthday is today, Breonna Taylor, Charlena Chavon Lyles, Sandra Bland, Maya Hall. I say their names because it's that critical. I say their names not only for you to center their lived experience, to also understand that regardless of what they did, these killings are not justice. And while we're talking about the racialized experience as it relates to criminal justice, you can change this conversation to healthcare. You can change it to education. You can change it to housing. You can change it into family law. You can change it into every area of law that speaks to you and the work that you're getting ready to do. So I thank you for being prepared to engage in hard conversations, to do the hard work that's going to build your character, it's going to build your understandings. It's not easy, it's raw on purpose, it hurts on purpose, and you're going to be better for it, and our society will be better for you being prepared to do this. Thank you.
Thank you, Sonia. Thank you, Sonia. So I didn't expect that we would go exactly according to schedule, and that's okay. That's part of what it means to be a family, and we figure things out. We had this segment that was originally scheduled for Q&A, but we, one, had a decent bit of Q&A on the chat, and two, I want to implore everybody who has lingering questions. One, you can always email our faculty, talk among ourselves. Anybody here is willing to help you find a particular answer. But I really also want to respect the promise we extended for at least some period of direct engagement in conversation with each other. Sonia talks about the need for some difficult conversations, for uncomfortable conversations. Well, I think it's time that we begin engaging in some of those conversations. So I have to let you know that when we break out into Zoom breakout rooms, I just learned this morning that there are some limitations to our own technology. I was hoping that we would all be able to choose our favorite breakout room, but it looks like we have the option of handpicking 115 people individually, or just assigning them random rooms. And so I think you'll probably find your name assigned to a random room, and you'll follow, and hopefully meet some people, introduce yourself, and engage some good conversation. And to help us guide those conversations, we actually have one final speaker today, an amazing student, Valde Sanchez, who's going to give us a little things to think about and perhaps some ground rules on how we can engage with each other more effectively. So Val, are you here? All right, welcome.
Hi, hello. So I'm Valdez Sanchez. I'm a rising 2L. Oh, I made it. And I'm also the vice president of the Black Student Lawyers Association, and I'm the ally coordinator for Lambda. So outside of the law school, I'm actually a professor of communication studies, and I'm also an equity, inclusion, and diversity trainer for universities and businesses. So that's, if you're wondering, like, why did they ask that person to talk about ground rules? That's a little bit of my background. So the first thing I want to start with is just to keep in mind when we break out into these rooms is emotions are very raw. So just be very mindful. And that leads me to my next point in terms of intent versus impact. Too often our intentions are extremely pure and we're just trying to say what's on our heart and we're trying to speak openly. But the impact of those words can be very triggering for some of us. They can be very isolating for you. So if someone says what you said offended them, don't say, well, my intention was to be kind, because your intention at that moment doesn't matter. The person is impacted by what you said. So instead of dwelling on the intentions, think of, wow, I intended this to be something positive, but the impact was a lot more negative and hurtful than what I intended, and just listen. The other thing is your education and your learning is your responsibility. So we're extremely privileged to be here at the law school. We have so much access to resources. So a lot of things that we're seeing is people asking, well, what can I read? What should I look into? What should I? Well, y'all have the same internet as I do. So it's really important to be accountable to yourself and look into things like the book lists have been circulating. How to Raise an Anti-Racist Child, all of those things are out in the world. So please do your own research on that and don't just ask the only Black person that you know. I know my inbox has been full this entire week. The other thing is, like Professor Aranjani mentioned, we're all coming from different places. So be mindful of that and understand that if we're in these breakout sessions and someone starts talking about something that you're not familiar with, or they mention a name of a Black person who was murdered by police, and you're like, oh, I don't know that case, tell me about it. Instead of doing that, write a note and look it up on your own. Because I know when I'm talking about a case that was really impactful to me, and then I have to stop and then fill somebody in on what the case was, it really just takes away from what I was trying to say. So just be aware of that. And if you're like, oh, you know, just write it down and then look it up later. Let the conversation keep moving. Also, laughter is often a sign of discomfort. So don't be super offended if you're in these breakout sessions and you say something and someone kind of chuckles and they go, oh, they're not laughing at you. They're not laughing at what you said. They're just stunned and they're uncomfortable. And sometimes we have that visceral reaction. So just kind of keep it moving. If you make a mistake, just apologize and keep going. And also the language that we use matters. Coming from a communication background, I know let's not use the words rioters and looters when we're talking about protesters. Those are very different things. And someone who grew up during the protests that took place against the verdict for Rodney King, those are very different groups that are acting in that capacity, and understanding what motivates people in this moment. I know I've been on the verge of tears and just screaming for the past month or so, being the mother of 2 Afro-Latino boys. So just be mindful of the words that you're using and how you're referring to these people who, like Nikki said, are fighting. We're literally just fighting to exist. And I know I'm counting down the days for when my children are no longer looked at as cute, but are looked at as a threat by the police. So if that's your headspace, and then someone goes, oh, these looters and rioters, you know, that stops the conversation right away. And that tells me I'm not safe talking to you. So be very aware of the words that you're using in this moment. And lastly, I'm sorry, there's 2. If you're talking about Black people, say Black. It's not a bad word. Just say Black. I'm talking about Black people. This is a Black Lives Matter movement. We're talking about Black lives, queer Black lives, trans Black lives, disabled Black lives, working poor Black lives. That's who this moment is about. So you don't have to say people of color. You don't have to say BIPOC. Just say Black people. And African American and Black isn't interchangeable. Not all Black people are from Africa. So just say Black, okay? It's fine. We're not going to be offended. You don't have to hesitate. Also, the last one, and I promise we'll get into these groups, is white fragility. So a lot of times when we talk about race, when we talk about racism, when we talk about white supremacy, white people automatically want to say, that's not me. honey, we're not talking about you. If that's not you, that's fine. You don't have to prove it to us. But understand that if we don't say those words, we're not having any type of progress. We're not seeing any kind of change. So say the words Black, say the words racism, say Black Lives Matter, and let's have this conversation. If you're feeling uncomfortable, but you're not physically threatened, you're not emotionally threatened, you're not mentally threatened, you're just uncomfortable. So often what Professor Gibson Rankin said, where the police are called on Black people for just walking down the street. And then you ask the white person, why did you call the cops? Well, I was afraid. You weren't afraid, you were uncomfortable. Fear is when I see, cop lights pull up behind me and I'm alone in my vehicle. That's fear. Fear is when I send my children to school and I don't know if they're going to have a teacher who actually validates their identity or who's going to make them feel small for having more melanin in their skin. Fear is not knowing if my kids are going to make it home once they start driving, just because of the history of this country. So fear is very different from discomfort, but white fragility teaches you that those things are interchangeable when they're not. And that's what leads to these calls. So if you're sitting in these groups right now and you're feeling like your heart is racing, you're feeling flush, you're feeling angry, you're feeling unsafe, sit with that a minute and ask yourself, am I actually unsafe? Is my life threatened right now? Or am I uncomfortable because someone is saying something that I'm not used to hearing? So please stay Black, don't erase us any further. This isn't a people of color movement, although a lot of people of color have helped us. It's a Black movement, and you need to acknowledge that. And also, let's just keep having these conversations. They're uncomfortable, yes, but we grow when we're uncomfortable. So thank you and good luck.
Wow, thank you. So right now, I think that Tony is going to work some magic and assign us all to some breakout rooms. We have about 20 minutes left, and this is not the end of